Okay, I think we're recording. I hope we're recording. This is our first major content lecture here in tribal politics, and it's one of my favorite classes to teach. I have a lot of things I want to tell you, so I hope I can remember all of the important things as we work through this chapter. It's based on information from the Reading, Wilkins, and Stark Chapter 5, although I've added some other things in as well. So if you look at the background of this picture, you see the beadwork that's in the stream, and that's a wampum belt. And I wanted to draw that to your attention because it's a good metaphor for the relationship between federal government and Native tribes. Because the two-row wampum, which is the symbol of the first treaty signed between a tribe and the federal government, symbolizes the two governments existing side by side. It shows their sovereignty, it shows their strength, it shows their coexistence. And so I think that's a great example of the gold standard of what we could hope for in terms of the relationships between tribes and the U.S. federal government. So this next graphic was actually, the idea for it was actually designed by Stephen Greetham, who you might have heard of. He's a major attorney for the Chickasaw Nation. And he kind of laid out the simple timeline that helps us see this long-term relationship between tribes and the federal government. And so on the left side, you see contact, and on the right side, you see today. And then we've seen this variety of phases that we've gone through in our relationship. And the dividing marker is 1871, and I'll tell you why in a few minutes, why that's a big deal of a date. So basically, early in our history in the United States, the federal government saw tribes as co-equal governments with whom they should make treaties and be totally equal. But then after 1871, tribes were seen less as a co-equal and more as just a resource to manage. And if you want more evidence of that, think of the fact that the United States policy is made out of the Department of Interior, so which is where we see like the BIA and any Indian policy offices are in the Department of Interior. And what else do they manage in there? They manage public lands, they manage mines, and they manage Indians. So it just goes to show you what the orientation our government has had, at least since 1871. Although you'll see through this lecture, the relationship is very tangled, it's very nonlinear, and it's very frustrating. So I know we have a number of people in the class that don't have the legal background, so I just wanted to say a few things about the relationship between tribes and the federal government. So the style of government we have in the U.S. is called a federal republic, which is a fancy way to say we have multiple sovereigns sharing power in the same system. And the three major sovereigns would be federal government, the states, the 50 states, and then all the tribes. And so in terms of jurisdiction and power, all three of these types of governments share power within the same system, which is awesome and complex, but also kind of frustrating. We also have three branches of government, and in the U.S. federal government, we have legislative branch passing laws, executive branch that takes that law and carries it out, and then the judicial branch, which interprets the law and the Constitution and tells it what it means. So why is this important? Well, most of the time, tribes interface with the federal government. There are just a few instances where there's interface with the states, and that might be times when they could compact and make special arrangements. But for the most part, if there's a government-to-government relationship, you want to go with the head of the state to the head, by state I mean the head of the country to the head of the country, and that's not going to be a sub-federal unit like a state. It's going to be the federal government. So that's kind of important, just in terms of respect for how tribes are talked to by a government. And then a little later in the lecture, I'm going to talk a bit about the three branches of government, and so that's going to become a little bit important also, like which branches of government really become important in creating the policy toward tribes. So this is just a quote from a really cool legal scholar named Walter Echo Hawk, and he wrote, "No legal system is accountable or responsive to groups who lack access to the courts. So he wrote a book called In the Courts of the Conqueror, and that reminds us that every decision about Native tribes that's been made by the federal government, like the judicial decisions, have all been made by the federal government. We'd have no unbiased arbiter in this relationship. And that's true with any government-to-government relationship. It's horizontal and not vertical, so there's no enforcer of the decision. But it's especially galling when you have two sides in dispute, and then one of the sides also gets to control the court system. So it seems kind of unfair. So think of other instances where due process or rights have been denied to people, like Jewish people in Nazi Germany, blacks in the Dred Scott case in the United States, saying blacks basically are not people and can't bring cases to court. And then we see that in the same thing, natives with the Cherokee Nation versus Georgia case, saying that they could not bring their claims to the court. Okay, so a couple other vocabulary words I wanted to mention. Number one, tribes are sovereign. So sovereignty means you have the right to control your territory and control your people. So if tribes are sovereign, for example, the Chickasaw Nation frequently says unconquered and unconquerable Chickasaw Nation, they're asserting that they're a sovereign nation, that they have the right to govern themselves. So tribes are sovereign, and I'll give you some more vocabulary for that in a minute. But then it's also subject to the whims of Congress. So have you ever heard the word plenary? Like if you go to a conference, there's a plenary session. And that means it's like the everything session where everybody goes and all issues are discussed. So plenary power means total power. So we have this weird conflict where tribes have sovereignty, yet the federal government, especially Congress, has plenary or total power over tribes. For example, if Congress decided to pass a law that said tribes are no longer recognized by the federal government, could they do that? And the answer is yes. They could abolish federal recognition of tribes with one act. So that just goes to show you, how are we going to find a balance in a system where tribes have sovereignty, total power, but also Congress has the power to reduce anything about that relationship? So again, I mentioned already that the power to regulate tribes or regulate this relationship is a federal duty, which means states don't really figure in all that much, except for we'll see later sometimes how they do. And then because of the land relationships, the trust relationships that have evolved from the doctrine of discovery and the idea that the natives have a legal right to land, but it's going to be held in trust for them by the federal government. That provides a fiduciary or a powerful legally actionable duty that the federal government holds for the tribes, which they've done a very poor job of upholding that duty, but that duty exists nonetheless. So a couple of things: sovereignty, plenary power, the relationships federal to federal or head of state to head of state, and then the government continues to this day to have a duty to tribes because of the dispossession of land that occurred over the last several hundred years. Okay, so what is a tribe? There's a lot of definitions of tribes. The one that's really the legally most relevant here is federally recognized tribe, because it enacts and it springs a lot of different rights and protections because of that. It's a legally relevant term. That doesn't mean that there aren't other groups of people or bands of natives that consider themselves a tribe. That's totally happening, and that's also a thing. But for our purposes, a federally recognized tribe has more privileges because of their relationship with the federal government than a tribe that's not federally recognized. We also have some tribes that are state recognized. Some states have extended recognition, but again, that doesn't extend the federal recognition. And this crazy slide just shows you in Oklahoma, this is a list of the 39 federally recognized tribes and tribal towns. There are over 500 in the whole United States. California has the most tribes with over 100, but if you're looking at tribal villages, you have Alaskan tribal villages, over 200. And so looking at this map of Oklahoma, you can see some of the largest areas: Cherokee, Creek, Seminole, which is the little blue one, Chickasaw, and Choctaw. That's what we call the 5 tribes. Historically, they used to call it the 5 civilized tribes. I don't say that. I say 5 tribes. And the 5 tribes have a legally distinct situation from the other tribes in Oklahoma because they negotiated the removal treaties and their land is held a little bit differently. So when we look at laws relating to tribes in Oklahoma, you got to ask, is it a 5 tribes tribe or is it not? Because the law applies differently. For example, if a person who is 100% 5 tribes wants to convey a piece of land because of the protectionist laws that we've passed, that person actually has to go to a judge and have the judge sign off on that. And that's not true for non-5 tribes people. And it's because the title of their land is more perfect. And so they were trying to protect people from conveying their land away from themselves through fraud or other means. So very complicated. I like to say this is why we'll always have lawyers, because this is very complicated and they always need people like us to figure this out. So this is North America, sometimes called Turtle Island, that shows basically 100% of this land was controlled by Native Americans. And over the last several hundred years, you see incursions into these land holdings, dialing it all the way back to less than 1% of the land. So as I talk to Native people and they talk about their relationship with the land, like their goal is to try to get this land back and regain control of it because they see it as theirs and rightfully theirs. So we've gone a long way from total tribal control to almost no land controlled by tribal governments. Okay, so we're going to go through a historical timeline. And I always think about Martin Luther King Jr. and what he said about change. And he said, "The arc of the moral universe is long, but it bends toward justice." And what this says to me is we're going to make progress toward the correct answer. We're going to be marching on this road and we're going to be moving in the right direction all the time. But that's not the case when it comes to the U.S. federal government as it makes policy towards Native Americans. Sometimes the policy has been very beneficial and respectful, and other times it's genocidal. It's, okay, we're terminating you now. So it's just hard to imagine why thoughtful people with good intention would end up making policy that widely varies from total respect to total annihilation. So I don't really have the answers, but I think the more we study the backs and the forths of this policy, and also the disrespect and the casual racism that pervades this policy, I think maybe we can learn from it today, and at least going forward, maybe our policies won't be so erratic, because they're definitely erratic. And the word I've used before to describe this relationship is just highly ambivalent. The U.S. federal government has an extremely strong fiduciary duty, perhaps their strongest to any other people in the world, yet they've dealt with it so casually and disrespectfully. So many groups use the law as a weapon or a shield, but Echo Hawk basically has said that the tribal nations hate to be dragged into the courts of the conqueror because they really don't know what's going to happen next. Nothing really good has come out of these courts. And again, Echo Hawk, even in the Supreme Court decisions, the legislative record that we read, the president's comments, like going back to even Thomas Jefferson, who you think of as the man who embodies the idea of equality more than any other American. The way he talks about natives is just completely racist, and it's as if he sees no value in these people, no equality in them as men. So inferior, ignorant, savage, heathen, civilized, even the idea of the civilized tribes. If you have never thought about that before, if you're saying these tribes are civilized, basically you're saying these other tribes are not civilized. They're just barbaric. John Marshall, when he wrote his opinions in some of the Cherokee cases, he basically says, leaving the land in the hands of these barbarians will leave it undeveloped. There's no sense in in protecting Native rights, because they're just not even worthy of any kind of respect. So we follow the law. And the reason I'm bringing this up is we are held to follow the law, and the law has put us, our path is, it's not easy to get to a place of equality when all the laws are written in such an unequal way. All right, so back to our timeline. You can see the big break in 1871. Before 1871, tribes were seen as the sovereign foreign governments that they were, and the U.S. federal government used its treaty powers to make treaties and decisions with the tribes, which somewhat constrained their activities. Although, I mean, if you think about who breaks treaties, the federal government has broken nearly every treaty they ever signed. But at least it shows the intent of the federal government to treat tribes as a co-equal and not as just an unequal partner to be managed. So during this pre-contact and colonial time, I can't read this, 1820, some of the central themes are just destruction, death, treaty, and the tribes trying to exert their sovereignty. So before contact, before the first colonial conquerors came to this land, there might have been over 100 million natives developing civilizations and thriving. Today, there are less than around 5 million in this area. So the relationship was characterized by treaties. You come to a strange land, you see people there, you create treaties with them, and you try to respect those treaties. So the first treaty was in 1613. Tribes and the British government signed treaties that after the War of Independence, the federal government, U.S. federal government, then either had to respect or negotiate their own treaties. Tribes under the Articles of Confederation, which was the first government of the United States, they were also treated as co-equals with the U.S. federal government. And then if we look at the U.S. Constitution, tribes are mentioned in there. In the Interstate Commerce Clause, it says basically Congress is going to regulate commerce among different countries, among the states, and with the Indian tribes. It's listing them as a government to be treated equally. So we see from these early colonial times treatment of tribes as co-equal sovereigns, and that's what I mean. That's what was going on here. So in 1820, then we moved to an era which is going to set the table for removal of tribes from the eastern portion of the United States. This idea of manifest destiny, the idea that the colonizers were going to be able to extend their control all the way from the east coast of the United States all the way to the west. It was very pervasive, and tribes, especially that had been pushed south or lived in states like Florida and Georgia, were being squeezed. They were having white people come and squat on their land, and so that was really coming to a head. And so we have these three important Supreme Court cases. I'm not going to go into the details because it's not as much of a law class, but basically these three cases still are referred to today as sort of setting the table for this relationship between tribes and the federal government. And so one thing we get from these cases is the idea that tribes are domestic dependent nations, which, okay, so they're nations, but they're dependent. So it also embodies that conflict between understanding that tribes are sovereign, but also we're going to still kick them around a little bit. So basically, the Supreme Court held that tribes did not own their land. They had a right of occupancy, and they can't convey or give away or sell things that they don't really own. And then that pushed tribes out of Georgia and out of Florida, setting the table for the removal era, because if the white settlers were all coming in, that was going to push the tribes somewhere else. And so tribes such as the Cherokee Nation, Choctaw Nation, Chickasaw Nation, they saw the writing on the wall, and they actually came to Oklahoma to scout their new land to see where they might want to put their tribes and buy their land, because they were actually trading land that they held in Florida and Georgia and Mississippi and Alabama for land that was going to be theirs in Oklahoma. So They came and surveyed, they came and decided where they wanted, and they actually selected land as much as they could, especially the Chickasaws did this, that approximated the woodland homelands that they had in that they would prefer to stay in their ancestral homes. And so they had a little more power in this decision. They negotiated their own treaties. So this is important for Oklahoma because these treaties, like the Treaty of Dancing Rabbit Creek, still shape the politics and the law that goes on in Oklahoma. If you're familiar with the water settlement that happened a couple of years ago between Choctaw Nation, Chickasaw Nation, Oklahoma City, and the state of Oklahoma, it was all based on the Treaty of Dancing Rabbit Creek. So because the tribes could negotiate from a power of strength in the 1830s, they were able to preserve rights that they could still use today, even though in the meantime, almost everything imaginable happens to the tribes to wipe away their power. So it's a kernel of hope inside a very sad story because, I mean, many natives died upon the Trail of Tears as they moved from their ancestral homelands to Oklahoma. The Citizen Potawatomi call it the Trail of Death as they moved from the Great Lakes region, first to Kansas and then to Oklahoma. They did not survive. I mean, they're walking through blizzard conditions and many of them died. So Trail of Tears just sounds kind of sad, but Trail of Death kind of gets the message across more fully, more forcefully. So tribes settle in Oklahoma. They're actually very successful in developing, as you saw in the Modern Sequoia PowerPoint, hopefully, or the reading you had in Modern Sequoia. This is the era where tribes from the 1830s to statehood in Oklahoma are developing schools and courts and farms and water sources, and they're being very prosperous. So they were doing quite well in Oklahoma until statehood. So 1871, what's the big deal? Congress passes a law. Well, how can they do that? Well, surprise, they have plenary power. Congress passes a law that says that they're not going to make any more treaties with tribes. The treaty era is over. So who cares? Well, the importance of treaties is one thing because treaties are the supreme law of the land. It says in the Constitution, Supreme Court decisions, and treaties are the supreme law of the land. And now the basis of Native policy is not going to be something known as the supreme law of the land. It's just going to be the casual, unattended policies of Congress or different offices in the executive branch, just very casual, doesn't require as much oversight, doesn't require as much checks and balances. Why did Congress do this? Well, the thought is that the House of Representatives was tired of seeing the Senate get to make all the decisions about what was going on. And so they elbowed their way into the decision because a treaty only has to be ratified by the Senate, but a law has to be passed by both the House and Senate. So this reduces it adds the House of Representatives into the equation, but it also reduces the overall checks and balances into Indian policy. So tribes are no longer seen as the co-equal. Tribes are seen as something to be managed. I put this picture on. I know that peace medals are sometimes problematic. And what I mean by peace medals, a lot of presidents, like President Washington, for example, created medals, and then as he would go meet with tribes, he'd give his medal to the chiefs or important people within the tribes. And so they were sort of seen as a respect kind of thing. And now that it's sort of like a trinket, like trying to trick tribes into negotiating with you. But to me, it just sort of symbolizes that the president recognized these tribal leaders as co-equals. So after 1871, instead of you seeing fantastic delegations of tribes going to meet with the president, they met with all the early presidents. Some presidents complained that they spent up to 20% of their time talking about Native issues and meeting with Native delegations, because whenever one went to the White House, the president would drop everything and meet with them. But after 1871, this totally doesn't happen. So I just found this book. It's about American presidents and tribes, and this delegate went to go meet with a Paiute activist, went to go meet with President Hayes, and he basically just kind of dropped by and said, what's up? And then he just kept on moving. And she was really disappointed because in the past, people had been respected and met with at length. And then here is President Hayes just kind of refusing. And that sets the tone for what's going to happen in the future, where the tribal delegations are just not seen as an important thing to work with. Okay. So the allotment period is something that we should totally know about. And basically, this is the way that legally natives are dispossessed of all of the former holdings that they had. So after removal, a lot of them develop some treaties, they own the land, and then all of a sudden the land's out of their hands. Well, how does this happen? Well, what happened was the passage of the Allotment Act, or the Dawes Act, which basically said, instead of the tribe holding the land, each individual person will hold the land. And once you divide up the land on the reservation or the national territory and there's extra, then that was to be sold. So they sold this land and to non-natives, of course. And then also, once it's held by an individual native, it wasn't hard to dispossess that native of the land, because if they had money problems, you could convince them to sell it. You could trick them into selling it. Like in the Osage Nation, if you ever read that book about the dispossession of the Osage children of the Flower Moon, that in that book it shows how, because that land was so valuable, because it had oil on it, and it was very, very, it made the owners very, very rich. People would marry those people and then kill them. They'd adopt an adult and say, okay, this is my child now. And then somehow the child would disappear and their land would be stolen. So I'm not saying that all of it passed into white hands through fraud, but the thing you should know about the Dawes Act, or the Allotment Act, is this was the mechanism by which the natives were legally dispossessed of all of their land, some completely legally, some through fraud. So definitely a game changer for tribes and their power, because when they stop owning their land, they lose a lot of control. And also during this time, the Allotment Act was backed by assimilationist policies, hoping to basically kill the Indian and save the man. And so we also saw boarding schools. So natives were placed in boarding schools and stripped of culture and heritage. I consider this a genocide, because you're basically killing people's culture and robbing them of their heritage. And to this day, there are natives who either they themselves were in boarding schools and they can tell you about not being allowed to speak their language, or they can talk about their parents or their grandparents, and just think about all that cultural richness that was lost, and identity that was lost because of a poorly founded policy of assimilation. So and it also sets the table for why ICWA is so important, because taking babies away from Native families also was very prevalent even into the 1970s. And so the Indian Child Welfare Act was passed to try to keep those children in Native homes, to try to not only keep the family together, but it also preserves the culture and preserves the Native ways. So then we move into limited self-rule. So you might think about this time period in American history. It's during the Great Depression. The Great Depression starts in 1929. And because President Roosevelt was trying to figure out ways to sort of get people back on their feet, he wanted to help tribes just have their own, like, Indian New Deal is what it was called. So he passes the Indian Reorganization Act that allows tribes to reorganize and write their own constitutions. And to this day, even the Chickasaw Nation's constitution is based on the principles found in the Indian Reorganization Act, or the Oklahoma version that passed in 1936. So these laws actually were supposed to provide some aid for tribes, but the most important thing they did, which if you were starving to death in the 30s, this didn't help you very much, but it created the kernel of being able to revitalize governments. This act is still relied upon for revitalizing the governments of tribes. And this act also ended allotment policy. So then we move forward, and you're like, all right, now we're moving into some good places. Well, then we get termination. All right, what about revitalization. Well, moving on, we're moving on. People thought the federal government was too bloated after World War II, and one thing they could do is just terminate tribes. All right. So Choctaw Nation was literally one day from being terminated. Many tribes were terminated. Tribes were relocated. And then Public Law 280, if you're interested in the law, that is a law that also reduced the power of tribes, although not in the state of Oklahoma. So this is definitely a time of reducing the power of tribes. So thanks a lot, President Truman. Self-determination. So 68 to 80s. President Johnson, you know, he loved the Great Society and these kind of welfare-ish kind of programs. And so he found some ways to use government to like assist tribes, but this didn't really increase the power of the tribe. The person who really did that, unbelievably, might be President Nixon. Nixon is like an unknown big player in Native policy, because for one thing, he ended the termination policy in 1970. It was still a policy in 1970. He also, let me say, he had been coached by a guy named Coach Newman at Whittier College when he was in college in California. And Coach Newman was a Native, and he always talked with Nixon about how Native policy was such a poor area, and someone needed to get in there and do a better job and preserve tribes and Native ways. And Nixon took this to heart. And people don't really know this about President Nixon, but his sympathies that have been developed as a football player for Coach Newman really have lasting impacts even today. So we move now into tribal self-governance, even stronger than what we saw in the last era. And some of these policies came from the Nixon era, from the Johnson era. For example, the Indian Self-Determination and Education Assistance Act. This is like an act that allows tribes to administer their own education programs, administer their own housing programs. And so you have all these programs that are created by the federal government, but instead of an agency like the BIA coming in and running it, you're having the tribe run it for themselves. You're not extending this colonialist relationship. So you're actually developing the power of the tribes. And we'll talk later about the National Indian Gaming Act of 1988. You might have noticed that in the Modern Sequoia chapter. Something President Obama tried to do when he was president was create promise zones, which is like a free enterprise option for more investment in certain areas. And then the big question mark, I guess, for right now is what will President Trump do with tribes? I know that he appointed lots of natives from Oklahoma, including Ben Keel, seen in this picture, into different areas of the federal government. So it's unclear what his lasting legacy will be with Native issues. So finally, we get back to our timeline once again. So you can see, hopefully, why we have this big lightning bolt in 1871. You can kind of try to test yourself and see why you think it's different to treat tribes as a foreign ally versus a domestic resource, and what difference does that make? So I started working on the list of homework questions. Here are the questions. These are also going to be put on Blackboard for you to find. So I hope this is useful. I hope that you'll let me know if you have any questions. And moreover, I hope it recorded.